Welcome back to the second half of this episode featuring the testimony of Kimbal Musk and the SolarCity Bailout Trial against his older brother Elon. We left off with Lee Rudy, lawyer for the plaintiff's side, asking Kimbal the cook about share prices and exchange ratio determinations with regards to mergers and acquisitions. As self-appointed master negotiator, Kimbal was answering the lawyer's questions as best he could, which wasn't well, and his time in the hot seat is only about half done. Now to start, Rudy would like to confirm with Kimbal that as a basic investment strategy, you only buy discounted stocks if you expect that price to climb. Something Kimbal really doesn't seem to have a grasp on. Same thing with the solar industry in general, actually, since he says, I don't think any solar company is struggling right now. You can be a mom and pop or you can be an independent SolarCity, and you're having the time of your life in this market. So let's refer you to the chart depicting SolarCity's and Tesla Energy's recent performance against their competitors. Rudy recaps the highlights at the time of the bailout negotiations. Charts were dropping, Kimbal's margin loans were getting called starting at $30.80, but Kimbal says he called a low of $18, expecting the stock to rise again. A stock that was getting hammered with diminished guidance and falling earnings, there was no reason to think this was going to change course. In Rudy's words, no rational basis to believe SolarCity stock was undervalued and was going to go up. Kimbal tries at this point to make himself sound clever by comparing SolarCity to the early days at Amazon, but there is no equivalency there. And then he tries telling the court this sales price drop was all due to the entire stock market collapsing, which really wasn't the case at all. There was a 10% dip in the first quarter of 2016 for the market writ large, but certainly nothing collapsed. Moving on, Rudy focuses on why Musk and Gracias were the only two people recused in this transaction, and the fact that Kimbal's obligation to recuse himself was never discussed. Rudy brings up a slide that would look something like this, and proceeds to make all the connections to Kimbal. Kimbal is younger sibling to Musk. Musk sits as chair at both Tesla and SolarCity. They are both cousins to Lyndon Rive, CEO, and Peter Rive, CTO at SolarCity. Kimbal is close friends with Antonio Gracias, and he is friends with Nancy Fund, who is on the special committee at SolarCity overseeing the bailout from their end. Many of these friends and family members were also invested in Kimbal's restaurant chain, The Kitchen. Musk had $800,000 invested, Lyndon Rive another $1 million, Peter Rive was also invested, Fund and her buddy Ira Ehrenpreis as well, and the same thing with Gracias and Jurvetson. Moving to SpaceX, who held $250 million worth of SolarCity bonds, Gracias and Jurvetson from Tesla were also on the SpaceX board with Kimbal. Peter and Lyndon Rive were investors in SpaceX, Fund and Ehrenpreis were investors in SpaceX, so was the DFJ Fund, which is why Jurvetson got on the SpaceX board in the first place, and Jurvetson's partner at DFJ, John Fisher, was on the board for SolarCity. But none of these relationships, familial, cross-investments, friendships, none of it, were brought up by the Tesla board in consideration for why it might be prudent and likely legally required for Kimbal to recuse himself from these negotiations. So Kimbal didn't recuse himself. He also didn't inform the board about how his personal finances were being impacted by the falling share price at SolarCity. In fact, he tells the court it's none of their business, and that blows Rudy's mind. His failing personal finances in relation to his stock in these companies absolutely is their business. It's called full disclosure in light of conflicts of interest, and it's possible to construe this as a serious lie of omission. See, Kimbal didn't want his friends and family, all of them investors in his own company, to know he was having trouble staying afloat, bouncing money back and forth between margin lines like credit cards. In fact, what he tells Rudy is it wasn't interesting to them. The biggest reason why Kimbal was in that trouble was because the share price at SolarCity continued to fall. And that's just one of the reasons why Kimbal only put in 60% of the money he promised his partners at The Kitchen during their private funding round. Despite his ensuing monologue trying to explain himself, Kimbal actually states on line 9, page 531, that the reason why he wanted to put in the bigger amount was to convince others to commit to higher dollar values. And Rudy picks up on this. It wasn't about the $1 million you couldn't give The Kitchen. It was the exponential value of attracting additional investors if you had been able to put in the money. Welcome to the Musk family business model. Watch us put our money in so that you will also put your money in, which will make both of our investments worth more by creating a false sense of security for the other shareholders in this company. This is not unlike the teaming up of con men who rob people using tricks like the shell game. The performer sets up shop and has someone they know play a couple of rounds where they win quite a bit of money. Other people see them win and want to win as well, so they throw their money down. But of course, the only person to walk away with cash is the performer and his planted associate. Next point in the binder, Rudy asked again if Musk and Gracias recused themselves from the process, and Kimbal confirms that's right, but that's not what happened. JX1228 is brought up, meeting minutes from the June 20th, 2016 meeting, the first meeting that Evercore attended, where Musk is recorded as participating in discussion of potential exchange ratios. Gracias was also in the room, as they discussed the value and structure of a potential acquisition proposal for SolarCity. Kimbal chooses now to say he doesn't recall being in the room. He didn't make that claim on page 476 when he was discussing the same exhibit with Mr. Slifkin, but now he has to rely on the meeting minutes to say whether or not he was in the room. He was in the room. He was just obviously incapable of following the conversation, as he admitted earlier. Kimbal tries telling the court he doesn't remember Musk and Gracias being in the room. Of course, he can't recall if he himself was in the room, and that's why minutes of such meetings are recorded. Rudy needs to make the court understand how little Kimbal understood about this entire process, so he asks Kimbal directly, "So do you understand what an exchange ratio is?" Kimbal waffles. "I have been educated on it a little and I don't find it very useful." No would have been the correct answer here. He has no clear understanding what the term refers to. For those following along that are also unclear, from Investopedia, the exchange ratio is the relative number of new shares that would be given to existing shareholders of a company that has been acquired or that has merged with another. After the old company shares have been delivered, the exchange ratio is used to give shareholders the same relative value in new shares of the merged entity. This is entry-level M&A terminology, but Kimbal Musk does not understand the term and doesn't find this useful in a stock-for-stock transaction. He calls it irrelevant, without knowing what it means. But Kimbal is a good negotiator, so he thinks. And Rudy hammers this point with this question. You didn't need to know to be a good negotiator, like what an exchange ratio is or how it works. Just one more question that Kimbal Musk cannot give a straight answer to. Moving on. Rudy wants to confirm that Kimbal was aware Musk was communicating directly with Evercore about the price Tesla would offer in this potential transaction. Kimbal denies this and denies knowing this. Unfortunately for him, his videotape deposition tells a different story. Reading this exchange verbatim. My question is, to the extent there were discussions after this, after the company retained Evercore, Elon would have had discussions about possible premiums with Evercore before the board would have had discussions with Evercore about possible premiums, correct? Answer. The correct path is, the board and Elon discussed possible premiums. Then Elon had a discussion with Evercore about possible premiums, and then Evercore had a conversation with the board about possible premiums. Black and white interference and non-recusal, courtesy of the defendant's younger brother. But now Kimbal tries singing a different tune. He tries playing this off as a hypothetical, probably because his lawyers knew he'd screw this up for them in the videotape deposition. Except that's not how it was worded at all. Kimbal tries backpedaling on this for 2 pages, mentioning the correct path many times. But as Rudy steps in to cut this conversation short, he summarizes this nonsense. If you're trying to acquire a company, your testimony, as you sit here right now, is that the banker should talk to the board, get the board's view, then talk to the conflicted person, and then have the conflicted person talk to the banker about the exchange ratio? And Kimbal is forced to answer, probably not. Again, the proper answer here is no. Rudy asks 3 questions rapid fire that demonstrates Kimbal's ignorance and Musk's arrogance in this matter. Did you know that your brother typically received copies of all the Evercore materials for review before they went to the board? No. Are you surprised to know that? No. That would be part of the correct path, I assume, right? That would be part of the correct path. And that's a total facepalm. Rudy goes back to the meeting minutes where the exchange ratio was discussed. At the end of the day, the Tesla board agreed to a higher offer price range of $26.50 to $28.50. Evercore representatives who were hired to establish the offer price had suggested a much lower number that was ignored, and now Kimbal wants to claim he suggested that lower price as well. Kimbal tries saying that since the price was $18, he wanted to go in at $23. So according to Kimbal, he and Evercore were suggesting this lower price compared to what Musk wanted them to offer. Wrapping up the day, Rudy asks, you said you were recommending that the board offer a relatively lower price because you knew that it was going to go up from there. Isn't that what you said? Not necessarily knew it was going to go up from there. Sometimes you can get away with a lower price, but why not start lower? That is in fact what a smart negotiator would do. If Evercore's suggested offer price was $21 to $23, the smart person would offer maybe $18, since that's what the stock was trading at on the open market anyway. But that's not what the board did. The board decided to offer $26.50 to $28.50 because their conflicted CEO demanded it while he was in attendance during the meeting, and that was not smart negotiating practices by anybody's definition. With this exchange, court retired for the evening to wrap up day 2, to resume the next morning at 9:15, but we are going to keep going until we're done with Kimbal. The following day, testimony under cross-examination continues on page 551, found now in document 461. To start off day 3 with momentum, Mr. Rudy gets right down to business testing Kimbal's recollection of his own direct examination testimony conducted by Mr. Slifkin on the previous day. In particular, where the witness was going on and on about Powerwall and that particular page on the Tesla website. Kimbal explained during direct that Powerwall was bundled with every solar purchase. Kimbal also testified, as Rudy reminds him, that he didn't think you could buy a Powerwall without a Tesla solar purchase. And as we pointed out, that is incorrect. We noted at that point in the testimony that Sunrun carries these units, and Rudy brings up the Sunrun website. Sunrun is a SolarCity competitor, or it was when SolarCity was a thing, and they very clearly state the company sells Tesla Powerwalls with new Sunrun solar installations. So once again, Kimbal is either being ignorant or untruthful, but he tries to worm his way out of his previous answer by saying that there's too much demand for Powerwalls, so they only sell Powerwalls with Tesla energy. This false explanation only dug his hole deeper, and his rambling on does not help. To clarify things, Rudy asked directly, so you're saying that when Sunrun advertises you can buy solar through Sunrun and you can store solar energy with a Tesla Powerwall, that they're just putting that on their website, but they're not going to be able to deliver on that promise because there won't be enough supply for them? And the clueless cowboy again lies to the court with this statement. They're actually not a reseller of the Tesla Powerwall. They can say that, but they can't sell it. And we know this is a lie, because we called Sunrun and talked to a customer service representative named Tyler. There were absolutely no issues if we had wanted to order a Powerwall for the quote we asked him to provide. Nice guy, very helpful. Ask for Tyler. Now imagine that you're the owner of a Sunrun franchise and you're listening to this. Your next call should be right to Panasonic, lining up a supply agreement for Panasonic's competing product, the Evervolt, and then drop Tesla altogether. Following that answer, Rudy goes to the Tesla website, where it says right on there, Powerwall can be integrated with your existing solar system. Powerwall is compatible with solar inverters from SMA, SolarEdge, Fronius, Enphase Microinverter, Delta, and ABB. We continue to explore compatibility with other inverter companies. Kimbal then pipes up even though he wasn't asked a question, and he tells the court that he, as a director of the company, can get preferential access to the supply, which he calls constrained. Pretty sure there's a term for this, and rules in corporate governance about that type of preferential treatment for board members. Then Kimbal starts getting abrasive with Rudy about whether or not Tesla is actively selling Powerwalls through other companies, which they obviously are, and demands to see where online you can order these units without a solar roof. So Rudy brings up the Tesla website. Under step 1, place an order. Locate a Tesla certified installer to purchase and install a Powerwall. Kimbal refuses to accept the facts in front of his face and continues to insist you can only get a Powerwall if you order Tesla Solar, even when the order form for a Tesla Powerwall on the Tesla website is right there in front of him that has located Tesla certified installers. However, he tells the court, again, braggadociously, if you know me, I can help you get a Powerwall without a solar roof, because that's what it takes. And as Rudy rightfully informs Kimbal, you may want to amend your website. With Kimbal's incompetence on full display now, Rudy returns to the timeline where they left off. JX1557 is brought up, the actual report presented by Evercore to the Tesla board on July 19, 2016. And Rudy begins asking questions about key diligence findings that were reported, which Kimbal says he recalls. Number 1 key discovery is labeled liquidity situation. The first bullet point of this states that SolarCity's board was informed in February of 2016 that SolarCity faced significant liquidity concerns in May, August, and September of 2016. The second bullet point is Evercore telling the Tesla board that SolarCity's liquidity issues are continuing as of the time of this presentation. The third bullet point says if SolarCity falls below the minimum cash balance requirement, it risks default on its revolver and triggering cross defaults on other debt. Rudy brings up Kimbal's testimony from the day before. It seemed pretty fine to me, but I do know that their business was relatively complex, that they had, from what I could tell, significant cash deposits in my analysis. Yet the financial experts at Evercore did not agree with that assessment, since the $116 million they had on hand was not going to be enough to maintain covenant levels. Unsurprisingly, Kimbal states that he's very familiar with dropping below covenants, and that it happened many times in all of Kimbal's businesses. However, it's not supposed to happen at all. And just like his brother, he counted on the banks not honoring their contract by calling in the debt when that covenant was breached. Rudy takes Kimbal back to the first bullet point about the liquidity issues. And by doing this, he's going to let Kimbal demonstrate exactly how his story doesn't track. See, Kimbal starts off on a little speech about how companies don't look to get acquired. They want to build their business, and the only time they look to get acquired is when things are not going well. That would be completely ass backwards from a buyer's perspective, and that's why it's always important to look at more than one target. Given two companies with a similar price tag, where one is doing well, turning profits, and the other is losing market share, drowning in red ink, you would always pick the stronger company, but not in Kimbal's world. And as it turns out, that doesn't even fit Kimbal's flimsy narrative. Let's run an example here. Tesla paid $2.6 to $2.8 billion for SolarCity, and took on $3.4 billion in debt. Total cost of this bailout in 2016 was $6 billion. Sunrun, who currently claim to be the national leader in residential solar installations, has a market cap today of $5.37 billion with a share price of $25.93. In October of 2016, when this bailout happened, Sunrun shares were running $6.50, giving them a market cap at the time that Tesla bailed out SolarCity of $1.35 billion, half what Tesla paid in stock and 21% of the overall stock and debt transaction to acquire SolarCity. SunPower, another name that was mentioned as a competitor to SolarCity, today has a market cap of $2.9 billion at a sale price of $16.45. You could have picked them up in October of 2016 for about $5 a share, and a market cap of $880 million. Meaning, for what Tesla paid for SolarCity, they could have bought Sunrun and SunPower, two successful companies that are still operating today, and had $570 million left over for rebranding both companies or R&D or expansion. Back to Rudy, who questions Kimbal about how this scenario works in his head. So which is it? Was it the business was faltering and needed to be acquired, or the business had tremendous tailwinds and was about to do great? Kimbal can't answer that question, so he brings up Tesla as an example, when Tesla was in production hell and asked Apple if they would buy them out. Apple said no, and rightfully so. Why bail out a company that's floundering when you can start your own freshly branded enterprise in that space from scratch? Master Plan Part 2 is the next topic of conversation on the agenda. Musk published this document online the very next day after the Tesla board received information about the liquidity covenants and liquidity position. This was information that could and should have prompted Tesla to pull the plug on the deal. It's JX1618, authored by Musk, dated July 20th. The paragraph in question reading, "We can't do this well if Tesla and SolarCity are different companies, which is why we need to combine and break down the barriers inherent to being separate companies. The time has come to bring them together." This is Musk publishing on the Tesla website something that the board has just discovered is not as sure a thing as they were previously led to believe. And although Kimbal tells the court he had nothing to do with Musk publishing this online, there is an email chain that proves Kimbal is untruthful in that statement. Musk outlined to his brother exactly what was going to happen. And still, Kimbal thinks his brother was recused in all this. Despite an ongoing negotiation, Musk is drumming up public support in his Twitter and social media followers for this bailout. As Rudy states, the Tesla board was getting some pretty dire information and potentially had the option of pulling out of this negotiation if they realized they were about to buy a terrible company, right? Elon Musk, by putting out their Master Plan Part 2 the day after the Tesla board is informed about these diligence issues, that is a way of publicly committing Tesla to going forward with this acquisition. Rudy asked Kimbal if he was aware that Evercore had only just received the information about SolarCity's liquidity concerns, that Courtney Bean, the Evercore representative, had only just discovered that information before the meeting. In fact, Evercore told the board they thought it was extra important that Evercore be given the opportunity to conduct thorough due diligence to get to the bottom of those issues. He doesn't recall Evercore telling them, "We've really got to dig into this stuff," despite that plea being recorded in the minutes. Meanwhile, as Evercore needed the process to slow down, Musk was insisting the process be sped up and to close by July 23rd. Within 3 days of Part 2 being published, 4 days after the Evercore drop at the meeting. On July 16th, McBean wrote to her team and told them, "We should catch up after this. We are running out of time. Plan is to sign this week, and fairness is on Monday." Fairness is another term the great negotiator does not know the meaning of. If you don't mind me asking, what is fairness? In fact, Kimbal is so clueless about the term, the court has to intervene to prevent the plaintiff's lawyer from testifying here to explain the term to him. Rudy can't do that, but instead he asked Kimbal if he was aware that the timeline they were working under was set by Musk and Evercore. Kimbal denies this, but we already went through this with Musk's testimony and documents from McBean. Musk was controlling this process with daily check-in calls. At this point, the real story about One Riot comes out. Kimbal told his team's lawyer he was CEO of One Riot, but failed to mention it was an unsuccessful business venture at the time. The company was bought out by Walmart, with each engineer receiving around $1 million apiece, but Kimbal himself lost money on the deal, with about $30 million invested. Yet another Kimbal business foible, all the more reason to hold on to those board seats. Rudy informs Kimbal that Musk had insisted on and organized daily calls with Evercore to make sure things were getting moved along faster. That was apparently news to Kimbal, and those calls started right after Evercore found out about the liquidity issues. That was also news to Kimbal, who claimed to be unaware of these daily calls. Rudy goes to JX1673, Tesla board meeting minutes from July 24, 2016. The discussion revolved around the upcoming earnings announcement for SolarCity, which Evercore knew was going to be below their guidance. Evercore told the board that SolarCity's stock price would drop after this was released, but Kimbal doesn't recall that. So Rudy brings in the videotaped deposition of Courtney Bean, which read as follows. Question. When the board asked questions of you regarding the expected impact of second quarter 2016 financial results for SolarCity, what did you tell them was the likely impact on the trading price of the stock? Answer. Well, given that they were going to reduce guidance, the stock price would likely go down. Incredibly basic stuff. Not only does Kimbal not remember this, since he doesn't answer the question, he then states he doesn't even remember Ms. McBean, which Rudy has a hard time believing, and so do we. This is Courtney Bean. She's a very attractive, blonde professional that the Tesla team spent 2 days with in the summer of 2016. And as we all know, the Musk boys have a thing for pretty blondes. At the time of the bailout, Kimbal was single, and the woman he married in 2018, Christiana Wiley, was just recovering from her divorce from her first wife in 2015, a performer named Skin. Christiana is daughter to Sam Wiley, a billionaire from Dallas who declared bankruptcy after losing a juried civil trial in 2014 that convicted Wiley and his deceased brother Charles of securities fraud, after which the IRS hit him with a $1 billion+ tax bill. So apparently it's true, women really do search out men like their father. Christiana's dad and uncle bear striking career similarities to her brother-in-law and her current spouse. In the years before the bailout, Kimbal and the mother of his children, architect Jen Lewin, split in 2010. Around the same time, Kimbal was reportedly dating girls introduced to him by Jeffrey Epstein in 2011 and 2012, and Epstein tried to use that connection to get closer to the older Musk brother. Oddly enough, 2012 was also when Musk divorced Tallulah Riley for the first time. But getting back to the trial and Kimbal's claims about McBean, it's pretty safe to say that any single red-blooded boy is going to remember when this professional lady walks into a room full of middle-aged bankers in suits. Despite knowing he spent 2 days with her and the Evercore team, Kimbal still denies remembering her, or much of what was said during the meetings because, as he says, no offense to bankers, but I don't put a lot of stock in what they say. Rudy needs to clarify. I'm just right now asking you about your involvement with Tesla's financial advisor, Ms. McBean from Evercore, and it sounds to me like you didn't have a lot of interactions with your bankers through this process. Is that right? Cocky Kimbal, the guy using one credit card to pay off another on a regular basis, states, I don't consider bankers to be the best advisors. I don't consider them to be that useful. I avoid them whenever I can. The master negotiator who doesn't understand basic business terminology also has no use for bankers. What's the bet is because they can't dumb themselves down to his level to explain these simple concepts to him. Which is why on page 590, Rudy summarizes Kimbal's knowledge of the stock market reactions to failed earnings. So your understanding was the reason SolarCity's stock price would not go down was because the Tesla offer was out there in the market which would hold SolarCity price up. To this, Kimbal answers yes. Rudy confirms then that the opposite would be true. If Tesla withdrew their offer, the price would drop, which Kimbal also agrees with. Yet just a couple of pages back on page 581, Kimbal told Rudy that if Tesla had walked away from the negotiations, SolarCity would be a very successful solar company today, and that was just minutes ago. Back on 592, Kimbal is getting cocky again, responding to Rudy's question about his recollection of Ms. McBean's advice, with, "I recall not listening to her." So the videotaped deposition comes back into evidence. Question: sitting here today, what do you think would have happened to SolarCity if Tesla terminated discussion in this late July time period and SolarCity had to announce its second quarter 2016 earnings? Answer: it would have had a negative impact on the stock price, which would impact its ability to finance itself. Question: would it end up in default? Answer: unclear, but the risk of default increases. Question: and the board asked you these similar questions back on July 24th, right? Answer: I believe so. So you have this information and what seems obvious to you about what would happen if Tesla were to withdraw its offer or if the second quarter earnings came out, and you talked as a board about what to do in that circumstance, right? No, not necessarily what to do. According to Kimbal, the discussion revolved around price and how low they could go. Except, back a few pages, Kimbal is telling the court how the price would have been locked in once the offer was made. Kimbal thinks they could have gotten a lower price, but he says they didn't want to go too low, otherwise the shareholders at SolarCity wouldn't vote for the deal. However, as we all know too well now, all the major shareholders and the company were hanging on by a very thin thread in July of 2016, waiting on a deal that Musk had promised them would be done in May. SolarCity was not walking away from this deal, no matter what. As Lyndon told Kimbal in a personal email, SolarCity is seeing its ass, and we need to get this turned around quickly. So, at Musk's behest, Tesla submitted their offer before SolarCity released their second quarter numbers, and they propped up the share price of the company they wanted to acquire, which was definitely not in the best interest of Tesla shareholders. See, at the time, shares of SolarCity weren't trading at $26.50 to $28.50, they were down around the $20 mark, and if the second quarter numbers had dropped the price even further, Tesla could have scooped them up at a discount to that $20 level. Seems that the master negotiator had no game after all, none whatsoever. And that's where Rudy leaves Kimbal for his redirect by Slifkin, which you are welcome to read at your own leisure, but nothing of consequence came up that warranted additional questions from the plaintiff's side. Bringing us to the summary for how we would encapsulate Kimbal Musk's testimony in this action. At the time of this bailout, Kimbal Musk was experiencing financial problems of his own, stemming from personal debt that used shares or margin in Tesla to pay margin calls on his loans against his SolarCity shares as the stock price eroded. He was falling so short on promises to shareholders in his own company that he needed a $10 million loan from his brother so that he could fund $2.5 million of his private funding round for the kitchen, but wound up falling 40% short on that flex when Musk failed to deliver on a previously agreed upon loan against Kimbal's shares in SpaceX. Despite being intricately connected to almost every party on every side of this bailout, Kimbal did not recuse himself from this transaction and did not disclose his financial interest in this transaction and stayed on to negotiate the transaction for the board, despite having no knowledge of M&A terminology or process and absolutely no interest in what the professional financial advisors were telling the board about the deal. Makes you wonder what, if anything, they're teaching in the Queen's University business program that Kimbal supposedly graduated from. Kimbal's shares in SolarCity, which were collateral against his personal debt, would have become worthless if the company went under, and his personal financial situation would likely have imploded. However, because Kimbal stayed on the board and voted for the bailout, those 147,541 near-worthless shares he had in SolarCity were cashed in at around 9-1 for 16,394 shares in Tesla. Those shares split 5-1 in August of 2020, giving Kimbal 81,976 shares of Tesla for this bailout. And at the recent all-time high of $1243.49, they had a value of $101,925,421. To add to the 200,000 stock options he has collected as a board member of Tesla at the time. Tesla shareholders have actually been trying to get rid of Kimbal the cook for a couple years now, owing to the fact that he basically knows nothing about the industry, does nothing for the company, and doesn't even participate in any board committees. Shareholders voted on his tenure in the fall of 2021, and prior to that in 2018, but to no avail. As long as Big Brother has his 22% slice in the company, and votes are decided by supermajority, Musk's little brother puppet isn't going anywhere, and Kimbal will continue to collect his options every 3 years, just for keeping his boardroom chair warm. Now, before we wrap up this episode, an interesting development that's related to the brothers hit the news recently, and it has to do with Musk's sale of $16.4 billion worth of Tesla shares based on what he claims was a binding Twitter poll versus the timing of Kimbal's own sale of his Tesla shares. The two brothers are now being investigated for violation of securities laws and insider trading by the SEC. Based on this graph, the SEC should also be looking at, in chronological order, Ehrenpreis, Gracias, Baglino, Denholm, Kirkhorn, and Tenaya. All of these Tesla officers and directors sold large blocks of shares during the run-up in sale price triggered by the Hertz announcement that they were going to be buying 100,000 Teslas for their rental fleet. This is now known to be a very questionable announcement, to say the least. At the very top of this run-up, Kimbal sold $108.7 million worth of Tesla, very close to our calculated amount that he got through the SolarCity bailout. And he did this the day before Musk started selling off billion-dollar blocks of the same stock. The stock price has now fallen to 67% of that all-time high and has trended downwards since the beginning of 2022. Just one more thing for the SEC to investigate with regards to the brothers Musk. Thanks for tuning in to this episode of The Common Sense Skeptic. We may be able to do one more witness from this trial, hopefully Robin Denholm, before the expected decision is handed down in April, which we will certainly be covering. And then we're going to go straight into the next major billion-dollar class action suit against Musk and the Tesla board, in the same Delaware courtroom, but since this trial was Vice Chancellor Slight's swan song before retirement, he has now been replaced by Chancellor Kathleen St. Jude McCormick, who will be presiding over Tornado vs. Musk 2018-0408 KSJM, as this class action again sues Musk and the Tesla board of directors for billions of dollars in compensation. This time thanks to Musk's self-authored, self-enriching stock options compensation plan. This time the board of directors is not protected by D&O insurance policies, and they cannot settle ahead of time with their judgments against being paid out by insurance providers. This time the entire board will have to rely on Elon Musk to cover their ass and pay their legal fees. If you've appreciated this series so far, best way to help us out is to share the episode with your friends. Also hit that subscription button and notification bell so that you'll know when the Common Sense Skeptic returns.